by now. Let's respect each other's time, guys.
Yeah, sure. So yes, Chaman, I think what Arpita said that after this conversation also, how can we take this forward? Gayatri ma'am will be definitely we need your guidance, and you can definitely mentor us how to go ahead, and especially the young people, how can we take this as an agenda and convert this in the recommendation or policy, the campaign with the especially the Bombay Municipal Corporation. That's something we'll definitely need your guidance in the coming time. Yeah.
No, definitely. I'll also try and touch upon in my limited experience how much ever
Yeah.
I'm aware of.
Yeah.
But yeah, I mean, basically, we being a young country, I think it's high time with environmental, issues that we are facing with every passing day. It's going to be very important that every citizen is involved in a public law issue generally.
Right.
Farah, can you kick us off now?
Arpita, Stalin has joined. I can see him in the attendees. Can you add?
Okay, I can do that. Yeah, great.
Yeah.
Stalin, welcome to this panel. Great to have you. I think if you can turn on your video, that would be nice. We are about to start. Thank you. Yes, great. We can all see you now. Great to have you as well.
Welcome,
Farah,
Stalin, and good
welcome.
morning.
Thank you. Good morning.
Farah, you can take us off, and I'm also going to request Harpreet to start the recording, and I'm going to go live now on Facebook. Thanks.
Okay. First of all, a very, very warm welcome to all of you in this webinar, Wetland Matters. We're going to assess the role of law in management and conservation of Mumbai's wetlands. So before I introduce my panelists, I just like to point out that today, we have with us students and faculty joining we had registrations from so many different colleges. There are almost 50, and we have 4 people who will be representing us from the high courts, 4 from media houses, and all these other organizations. Now I would like to stop sharing this so that we can all see our panelists. I would request all panelists to stay on mute if they are not speaking during the live session, and yes, to keep the video on at all times. So very, very warm welcome to all of you, and hope we have the kind of robust discussion that we are trying to achieve today. So I would now like to invite Stalin over to speak to us about the importance of wetlands, about what are the different types of wetlands, and what is the current status. How much of the wetlands that Mumbai has is actually there right now, and what of it we have destroyed. Stalin, you'll have to unmute yourself.
Thank you, Farah, and thank you, Waatavaran Foundation, for this initiative. And I would like to do a small presentation. I don't know how much time are you giving me to do that, so I can pace it accordingly. So I can just run you through, because
yes, 10 minutes.
10, okay. So now, if you allow me to share my screen, I can I'll put it on. Can I share the screen?
You can share. You're a panelist.
Okay. Okay. Is my screen visible?
We can't see the screen.
Okay. One second. I just give me a second. I'll just figure
Yeah,
this out.
sure.
I think now it's visible.
Yes, I can see it now.
Okay. We go to the beginning. What are wetlands? Basically, what is a wetland? The term is very simple. It tells you what is a wetland. It's wet and it's land. So wherever water interacts with the earth, the soil, and stays moist or is waterlogged, that we would broadly define as a wetland. Now, if you go for the technical definition of wetland, it's a land area which is saturated with water permanently or seasonally. And it takes on the characteristics of an ecosystem. That's very important here. It's called, we are talking of ecosystem related characteristics. Just because you stored water in a huge tank, it doesn't become an ecosystem. It has to show biological indicators in it, like birds, fishes, all those kind of things. Now the depth, the primary condition is that the depth of the water should not increase beyond 6 meters. That is the first condition. And then you can call it as an ecotone between terrestrial and aquatic ecosystems. Now, we have many kinds of ecosystems on this planet, like marine ecosystem, the terrestrial ecosystems, the intertidal ecosystems, the the sanctuaries, the marine sanctuaries, all kinds of different types of ecosystems exist here, the wetland ecosystems, the mangrove ecosystems. So wetlands are the most threatened of all these ecosystems, simply because we have not realized its worth, and we are only facing the consequences of its destruction. Now, these are the broadly, if you talk about the kinds of wetlands, the coastal wetlands, the marine wetlands, the estuarine wetlands, inland, riverine, palustrine, and lacustrine wetlands. Now, these are the classifications broadly. When you talk of coastal wetlands, you're talking of the marine, where the water is salty, the shrubs, the salt marshes, the mangrove swamps, the brackish water, or wherever these kind of features are seen, you would call them as the coastal wetlands. Now, inland wetlands basically all fresh water. They don't have salinity in it. And the lakes and small river channels, the streams that enter the rivers, the ponds, all these things together form the inland wetland ecosystems. Now, what are the benefits to us? See, basically wetlands play a huge role in climate change and temperature control. They retain water during the dry periods, release the water into the atmosphere and keep temperatures down. It also keeps the water table in the ground high. Now it captures the rainfall, holds the water in it, it retains sediments in it. That's what the sediments, nutrients are the reason for the ecosystems to thrive in it. Now, when you talk of wetlands, you should remember they purify water also. The water which seeps in through the mud and comes to the further inland is purified, and it has potable water qualities. They are huge carbon sinks. We talk of carbon sequestration, absorbing carbon which is in the air. The wetlands are a big role to play in it. They are a barrier to erosion. They slow down the floodwaters. They stop erosion of beaches, river banks. So it's a huge ecological services which are provided. Now, India is a signatory to the Ramsar Convention in 1974. Countries came together and signed a declaration saying that we will protect all the wetlands. So Ramsar International is the body which basically broadly looks after all the wetlands of the planet. So they say that the wetlands, according to them, are areas of marsh, peat, land or water, natural or artificial, permanent or temporary, with water that is static or flowing. Basically, it's saying that if there is water for a large period of time on that surface, it can be called as a wetland. Now it incorporates riparian zones and coastal zones. Like I told you, both the freshwater areas and the coastal areas. Now, the additional benefits are that the wetlands are important for coastal communities, people who are dependent on fisheries for agriculture, and it's called as wise use of wetlands. Now, it also provides fuel wood. Like, for example, the mangrove wood is used as fuel wood by the coastal communities. It helps to produce salt, fodder, traditional medicines also. Now, what are basically the threats which come are the reclamation, overfishing, construction of dams, introducing invasive species, submergence of mangrove species, inflow of pesticides into it, dumping of industrial waste, and exploitation of mangrove forests. We have looked into mangrove because Mumbai's large areas of Mumbai are under wetlands of coastal wetlands. Now this is the Thane Creek. This is, though it is called the Thane Creek, it very much lies within the boundaries of Mumbai, and it's a sanctuary now. It is called the Thane Creek Flamingo Sanctuary. There are about an estimated close to 1 lakh birds in this sanctuary of almost 130 species of birds which are seen. So it's a huge ecosystem, diversely rich ecosystem which we are talking about. Now, this is the breakup of the kind of areas which are there inside these sanctuaries. We are starting from Mulund up to Mandala in Mankhurd. It's a total area of 795 hectares. Now let us see how we conserve our wetlands. This is the Thane Creek. It's supposed to be an important bird area. The important bird area is one which has more than 20,000 birds in it. We have 1.5 lakh birds in this sanctuary here. Now we have 3 dumping grounds, municipal garbage dumping grounds on our wetlands. And this is what was happening to the largest dumping ground in Maharashtra or in India probably. It's a 141 acre wetland. And this was the condition before it started. And this was in 2013 when you can see a huge large water body and a lot of mangrove areas in it. Then this is what was happening to it. It was being dumped, debris was dumped and mangroves were buried under it. Water bodies got reclaimed. In 2020, 90% of it is gone. This is what remains today. This is a huge garbage dump, 141 hectares today. Now, how many of us know, if I ask how many people know that there are lakes in Mumbai? How many lakes do we have? We have 34 lakes in Mumbai. This is a 2009 study by Golden Quadras and his team. 34 lakes. And if you look at it, practically every suburb, every small area has a lake in it. So these lakes are never inventarized. There are no record of these lakes for protection. The government says there's only one wetland in Mumbai, and this is the Powai Lake. You can see the crocodile in it. Now, the nearby areas of Mumbai, they are called the Mumbai Metropolitan Region. Uran, for example, was the biggest wetland in Maharashtra. The huge wetland of almost 4,000 hectares. And there what we decided to do was to set up an airport. First the airport came in, then the township started coming in. Now this was given for an SEZ, a special economic zone, right in the middle of the coastal wetlands. The areas are walled in, so people can't see what's happening inside. This is how they start reclaiming the areas. They destroy this complete habitat. And this has happened while the court proceedings were going on. And this is what remains today. Nothing survives. So what happens when you destroy wetlands? For example, Chennai had a land which was, Chennai was an area with 80% of land under wetlands. We are less than 15% remaining today. So what happens when you destroy wetlands, when you reclaim it? Today, Chennai faces water shortage, higher temperatures, increased flooding. This is what happened to Chennai. You can see. This is the Chennai airport. And don't worry, the Navi Mumbai airport will resemble something like this in the coming days, whenever it starts. Now, what drives this we will be discussing as we go around. And what we are missing out is on the opportunity of wetland tourism in Mumbai. There is so much to explore and so much money to be generated while protecting these wetlands. These are all pictures which we have taken ourselves in the sanctuary. So we are blessed actually. We are a city with 2 protected areas for wildlife in it. And such huge amounts of wetlands, almost 4,000 hectares exist along the creeks of Thane, in the Thane Creek belt. Now, mercifully, because of the sanctuary status, it is remained protected. But if you talk overall, we have lost more than 40% of our wetlands. So the state of, no, sorry, only 40% remain. We have lost almost 60%. It's only these mangrove areas which are seemingly untouched today. But what we need to remember for everyone, for mankind, is that wetlands are your promise for water security. Without wetlands, you won't have water. That's plain and simple. Can't hear you. I think Farah is muted. Yeah,
Hi,
yeah,
Stalin. Thank you
yeah.
so much for your very nice presentation and for taking us around the importance of wetlands and why we need them and what is the current status of Mumbai today. We'll get into the details of the wetlands, especially in the entire Mumbai metropolitan region. We have a couple of questions as well. But before that, let's understand there are a couple of laws which govern these wetlands. What are these different laws? I would now invite Advocate Zaman Ali, advocate of Bombay High Court, to give us an overview of all the different laws that exist that can help us in managing and conservation of these wetlands.
Thank you, Farah. Thank you so much. And as already stated by Stalin sir just before this conversation, the fact that how diverse wetlands and wetlands ecosystem are, especially keeping in mind the inland wetlands and coastal wetlands, both have such grave importance in today's time when climate change is on our face, and especially in a tropical country like India, the consequences of climate change are going to be very different here compared to other areas. So, for example, we are going to have more rains in a shorter span of time, which clearly points towards saving, conserving those areas which have more water retention capacity. And that's where I believe wetlands step in, especially in these days. And just beginning with or on the point of providing a legal framework of what exists in terms of protection of wetlands. So initially, if we look at how all environmental laws have evolved, actually stem from where the industrialization occurred in the first go. So back in Europe, once again, sometime in 1960s, a lot of reclamation was taking place of all marshlands in the southern European countries, and that's where in 1962 there were 5 countries who had come together to discuss about protecting marshlands, and that conversation, those discussions went on for 8 years, which culminated into a Ramsar Convention. And Ramsar Convention is basically the convention to protect wetlands. And though it had come up in 1971, it was drafted in 1971, it was finally brought into effect in 1975. In fact, I just want to read out the entire name of the convention that shows the importance of what it is. It is not just Ramsar Convention, but the full name is Convention on Wetlands of International Importance, especially as waterfowl habitat. Now, this basically reflects the original emphasis that it's a waterfowl habitat means it's something to do with habitat for birds. That was the origin of this convention. But eventually, over the years, all aspects of wetlands conservation have come together. And generally, because of the fact that earlier there was a lack of understanding on the important roles of wetlands, which they have realized over time. And that's how, Ramsar even today has 5-year strategic plans amongst all its countries. Now, when it comes to just before I bring India in, at that point of time, the world was already having a lot of conferences on a decade to decade basis. For example, in 1972, we had a Stockholm conference on entire environmental issues. Then in 1982, you got the United Nations Convention on Law of Seas, and that also covered sort of habitats, inland coastal fisheries protection, habitat protection of, and the law of the seas, how your continental shelves and deep sea needs to be protected. Now, it is in that period of time where India at the same time was also seeing a certain change in the shift in its policies, not just because of the government at the helm thought that environment is an important issue, but also the device of public interest litigation, PIL, in India was also evolving in the 70s. And that is where the environmental aspects were also starting to be brought up before Supreme Court in 70s. And we know I'm sure all the law students have already heard of important environment cases done by Mr. M.C. Mehta. And there have been plenty of matters which help in devolving environmental jurisprudence from then that exist even today. So in 70s, we see with constant pressure, if I can use that word, coming from the judicial side by passing orders. There were certain enactments in 70s, such as the Water Act, had come into force, come into effect in India. So right thereafter, we had in 1982, where India finally became a signatory and it ratified the Ramsar Convention. So the idea of Ramsar Convention generally is that you have to be committed to ensure that wetlands of huge importance, and not just on the basis of their scientific value, but also on their cultural value, on the basis of how local communities are directly connected, like how Mr. Dayanand already said, be it on the coastal side or on the inland side. For communities, the wetlands issue has always been something which is very dear to local communities. Now, skipping, not skipping actually, a lot of conventions that had come up like before the United Nations. So we had in '92 the first UN framework on climate change that also established the fact that greenhouse gas emissions have to be stabilized, and that can only happen through protecting wetlands. And then eventually we also had conventions on biological diversity, which also sought protection of biological resources, especially emanating from wetlands. And so though the world has tried to devolve strategies, tried to bring in policies, India has lagged behind on that, on keeping up with the real measures that we have faced all this while. Because in India, you did not have any particular specific legal framework for protecting wetlands until 2010. And before that, you had Indian Fisheries Act, you had Indian Forest Act, which covered areas or lakes, ponds, all sorts of wetlands which under the forest areas. Then you have Wildlife Protection Act, which covered wetland areas, lakes, ponds, which are falling under national parks, wildlife sanctuaries. But this all of this can still be classified as indirect protection. Therefore, the consequential effect of this indirect protection is literally, in Indian sense, has been zero, because whenever you have an indirect protection, especially in today's time, the primary framework is that you need to protect a wildlife national park, you have to protect a sanctuary, and thereafter comes lakes, ponds, which fall within it. So the entire framework always revolved around biological diversity, which is good. I'm not discounting that, but with over time, how we have understood the value of wetlands, the need arose to have a special rule, special notification, special enactment to that effect. And that's when Wetland Rules of 2010 were promulgated now in India. Now the thing is, it is a subordinate legislation. It is a delegated legislation. It is not an enactment that occurred in a parliament. And that's where I think some fundamental issues also arise, because when bureaucracy makes rules under delegated legislation, not only you have the chance of missing out on core community localized issues, because you can't sit in Delhi at a central government office and frame draft rules which have to be released for public objections. Even if you release it, your framework, your how much of the issues that exist can slip out. And we have seen that whenever public objections are given out, not more than 10 or 20% of it get actually implemented in the final policy. So though Wetland Rules 2010 did come out, and it had certain provisions which I'll touch upon, it still lacked a bit of enough protective measures, but it was still something which had value to ensure protection in all inland wetlands and coastal wetlands remained. Now, if we look at Wetland Rules 2010, I think it is very interesting for everybody to please read the preamble, because it covers the scientific aspect as well as a brief history of how it evolved. So all the hydrological importances, as well as how it forms a huge habitat for so many species, is all written in the preamble, which is well appreciated. But eventually what we see is that the definition of wetlands, how wetland was defined in these rules, was still wide enough, but completely ignored the coastal wetlands. The idea there, it seems so, was that coastal wetlands will be protected under a different law altogether, which is the Coastal Regulation Zone Notification, CRZ notification. And CRZ had come in 91 earlier, which got superseded in 2011. And there's a 2019 as well, which we not a point to discuss here. But the fact being that the kind of protection inland wetlands get is starkly different from the kind of protection coastal wetlands are getting under these two laws. Now, when it comes to Wetland Rules 2010, you had clauses on restrictions of activities, and within which the first clause, which is clause 4, specifically provides for activities which are prohibited in any wetland area. So that includes reclamation, that included any sort of solid waste dumping whatsoever on any wetland was prohibited, and to some extent reclamation, and also any sort of new industries or expansion of any existing industry. So these were the prohibited activities, but it also included regulated activities within that ambit, which are permissible. And that activities, if you look at, are mostly in the nature of wise use, how it has been explained earlier, is that you can withdraw water for grazing purposes, for farming, paddy cultivation, agriculture, etc. So that regulation still existed. But one important clause then and there was that a central government, if it considers in public interest, though it is not defined in what circumstances could you consider anything as public interest, it could allow any wetland to be used for any non-wetland purposes on the recommendation of the state government. So this was something which still gave a sort of unbridled power. To what extent can they use or change the land use of those wetlands? So this was something still problematic. But one important aspect here was that 2010 rules always wanted a preparation of an inventory, which includes digital mapping with demarcation of each boundary of each and every wetland that existed in the country at that point of time. And this had to be published within 1 year. And we see that at least until 2016, there has been no such work undertaken. And it's only because of, upright citizens, people who really care for the environment, and students, everybody came together. And we have instances where High Court has passed orders saying that if you have not set up any wetland atlas, if you haven't inventarized or undertaken digital mapping, how can you face your own people to say that you're going to continue to protect wetlands? So this was something very good. There are orders of Bombay High Court time and again asking for protection, but it's only to show the approach, the attitude of the government so far that we see that if there's a strict timeline of 1 year, they have not implemented so. And so these were 2010 rules per se, and there are intricate issues also between authorities, which as of now I do not want to go into because of limited time, though I'm open to taking questions on that. But what we see now, this is the last point and very important, is that in 2017, the wetland rules of 2010 were superseded by wetland rules of 2017. Let us be clear that these are the rules that today stand for protection of wetlands as much as possible. Now they are superseding the 2010 rules. What we see once again in the definition clause, how they define wetlands, is an absolute narrowed down version of how wetlands were defined earlier. In the 2010 rules, wetlands not only included natural and artificial, but also included human-made wetlands, which included your tanks, reservoirs, and if you go to rural parts of the country, they are very important wetlands for the communities. They want to make sure, especially in today's time when drought is increasing in so many areas, in making sure that at least there's a governing government itself is coming up and ensuring that whatever you have dug, whatever you have done for your community, even if it's human made, we need to make sure it remains protected. That entire aspect has been taken away under this new rule. So not just wetlands, but it also excludes coastal wetlands. Once again, the entire ambit of CRZ notification that covers coastal wetlands is still not very protective, because you can still reclaim lands for many purposes under the CRZ notification. So the entire protection that we need, just as an example, for a coastal city like Mumbai, because it boasts of both inland and coastal wetlands, we are still very vulnerable at this stage. Very important aspect of wetland rules 2017 once again is, like earlier, similar to the 2010 rules, there are some categories which are prohibited even today, but the use of word of reclamation, the use of word reclamation under prohibited has been deleted in the new rule. And this is shocking, to say the least, because that is the first and foremost way we have seen by private players, by government authorities as well, where they have gone and reclaimed the land by dumping foreign mud, garbage, and we've seen how reclamation works. So that protection has been taken away. Secondly, there was like I earlier said, regulation of agriculture related activities, withdrawal of water, all that restrictions that existed that you can only do after taking permission has also been taken away. So we are at a position where this new law is now become even more regressive. There is no protective value remaining. It's only on paper. But if you see the implementable part of it, which was the core of your issues that had already existed in India, have been taken away. So that prohibition, the entire categorization of regulation has gone. And just subsequently, we have also seen, like I earlier pointed out, in 2010 rules, central government had the permission, had unfettered powers to go, and in the interest, in the public interest, it could go and use wetland for a non-wetland use. Here today, in 2017 rules, it does not even have the words in public interest. Today, in 2017 rules, it merely says that central government, for any purpose, can omit any wetland from the inventory and proceed to do whatever, whichever manner, bring whichever project on a wetland if it thinks to do so. So there's not even that particular small category that it has to be only in interest, in public interest, that has also been taken away. So these are major issues, though it is appreciated that you have devolved and delegated powers to protect wetlands from central government. Earlier it was under central authorities, now it has gone to state authorities, which is appreciated, but it has to be kept in mind that it is the state authorities who have not implemented 2010 rules by making those inventories till date. And with this backdrop, you know toning down and diluting our 2017 rules to this effect are really worrisome, and a challenge to the constitutional validity is already pending before the Supreme Court of these rules. And though I won't delve into what are the grounds in that petition, because it's a sub judice matter, I want to rest assured, tell people here, at least on the legal front, today protection for wetlands still remains really far away from the ulterior objective we need to, and it's a climate emergency today. And on that note, I want to close it. As also want to add just one last point, is that we have been seeing that draft EIA 2020 has been in a lot of talks and conversation amongst people, amongst young people. One important thing which I can connect with wetlands on draft EIA is that under draft EIA, you need to get a permission for environment clearance. But before, while your application for permission is pending for any project procurement, when it is pending, you can not only fence your area, but also can start leveling the ground, which means you can put anything on the top of it and make sure you can bring mud and make changes to that particular land. Now, if there is some sort of even 10% of a wetland that falls within that region, it will straight away go away without any protection. So these are a very important issues I feel needed to be addressed. And with this, I want to close it and make sure we all answer together the questions.
Thank you so much, Zaman. Gayatri ma'am, as Zaman just pointed out, that the 2017 rules which have been now which are now available are more regressive. Is there a kind of what is the kind of problem that you see in the way we define all of these things, like what a wetland is, for example, and what are the gaps that are existing in the latest law?
Yeah, thanks, Farah. I mean, there's so many issues. So I'll just very briefly try to give an overall picture of the problems that we are facing. First of all, I would say that there is no strong law on wetlands, preservation and conservation of wetlands. There is no law in India. We can talk about the Wetland Rules of 2010 or 2016. They do not protect the wetlands. And that is because our constitution, which is really a bulwark of all our laws in India, does not even have a provision for right to water, which is a basic fundamental right. And most of the Asian and African countries have provisions in their constitution which provide for right to water. That becomes the function of all laws and rules that are enacted by the country. Our constitution does not have that. The issue, I just want to add one part to Zaman's introduction, and that is that these states is gone.
Ma'am, we can hear you now.
Oh, okay. So land and water is covered under the state list. And that state list is entry number 17, which provides for water as a state subject. That water is that subject is also restricted to the issue of water supply, irrigation, canals, etc. The union list, which is basically entry 56, deals not with water, but it deals with issues relating to public interest, as Zaman said. So any act can be enacted if it is in public interest. We have the Water Pollution Act, which was enacted by the center in public interest. We have the Environment Protection Act, which was enacted in public interest and as part of the Stockholm Convention, since we were a signatory to that. So there is no concurrent list for water. There is no union list for water. There is only the state list. Therefore, we find that it's only certain states who have enacted very specific state laws, and I just point out those laws. That the East Kolkata Wetlands Act of 2006 basically sought to protect the Kolkata wetlands in West Bengal. The Kerala Conservation and Paddy Lands and Wetland Act basically prohibited the conversion of paddy lands for any other purpose. The Tamil Nadu Protection of Tanks Act of 2007 protected the tanks in Tamil Nadu because they were basically a large number of tanks were being destroyed. In Karnataka, you have the Lake Conservation and Development Authority Act. In UP, you have the Pond Development and Conservative Act. And in Haryana, you have the Pond Development. So each state had its own laws to tighten the loopholes that already existed at the national level. Now, when we look at the Ramsar Convention, only on that issue, I just want to point out the problems in that. Initially, the Ramsar Convention, as Stalin pointed out, basically dealt with the issue of the protection of the habitats where the migratory birds originated and where they migrated. So basically, even before the Ramsar Convention, there were treaties between countries, whether it's 1 or 2 or 3 countries, where basically the countries sought international cooperation in respect of migratory birds from the place of origin to the place of migration. Both areas needed to be protected. Therefore, the Ramsar Convention basically dealt with the habitats of migratory birds. It's only subsequently that it began introducing other aspects to the protection of wetlands. I will not go into all that, which Stalin has already covered. But one very important aspect of the Ramsar Committee, and there are a lot of defects in the Ramsar Convention also. One major defect is the fact that it says marine water basically is the depth of the marine water should not exceed 6 centimeters, right? And that was only in the context of the birds that needed to be protected. So now in India, basically we have adopted that by saying that it's only within the 6 centimeters depth that wetland should be protected and not deeper than that. So basically coastlands, which are much deeper than 6 centimeters, are not protected. Inland waters, which are more than, the depth is more than 6 centimeters, are not protected. So basically, instead of protecting and expanding the rights and the under the Wetlands Ramsar Convention, we are actually going back and taking a regressive stand. Now, as far as the Ramsar Convention is concerned, we've seen the problems there. But another major problem is the issue of the words wise use of the wetlands. Sorry?
Yeah, no, go on.
The wise use of wetlands. That was a word which was used by the Ramsar Convention in a particular context. It was used in the context of the preservation and conservation of wetlands. But in India, our laws are actually using it in a way to introduce so-called economic development in those areas. It is not for the purposes of sustainable development, but basically trying to introduce, as Stalin pointed out, with regard to the dumping grounds. You are introducing dumping grounds. Nobody even winks an eyelid to say that this is something which should not be allowed. It is something that will completely destroy whatever existing wetlands are there in India. So the wise use of wetlands is being misused by the Indian government in our wetland rules. Lastly, I would say that as far as the as I said, there is no law in India which really protects the wetlands, and it is basically the judiciary which was basically performing an act in terms of protecting the wetlands. So basically, we depend on the vagaries and predilections of the High Court judges. If the High Court judges are sympathetic towards environment, then you get a good favorable judgment. If they are not, and if they feel that economic development is more important, then you get a judgment which basically, so I mean, we have, it's a frustrating battle for us, because you go to court, it is so obvious that a particular land is a wetland, but the courts look at, like, for example, the dumping ground. I mean, it's something unbelievable that here you have a dumping ground where you can see that it is basically polluting not only the water, surface water, but groundwater also. And the court says, no, this is something that is required for the city. We do not have dumping grounds in city, and therefore this should be allowed. So you give more importance to economic development than to the protection of the environment. So it really depends on the judges who are actually hearing your matter. And that is because you don't have a strong environmental law that will really set the guidelines for passing any orders in terms of protecting the wetlands. Now, if we look at the judgments that have been passed, and I'll very quickly go through some of the judgments, which are basically judgments by the state high court. So you have the Calcutta High Court saying that the wetlands, the East Calcutta wetlands should be protected because they were also a part of the Ramsar Convention. They required specific provisions for protection, and the Calcutta High Court extended that protection. The Tamil Nadu High Court basically also, when a huge statue was coming up on a wetland in Chennai, the High Court said this cannot be allowed, and the statue was not allowed to be constructed. Here in Maharashtra, we have a statue coming up in the middle of the ocean, and with a huge area which will basically bring in auditoriums, shops, commercial complexes in the middle of the ocean. And that is supposed to be seen as something that is required for the state. Now, so therefore you had several judgments and orders passed by the various state high courts, which basically sought protection of the wetlands. You also had NGT orders, which basically protected the Dadri wetlands in Delhi. Then you had the protection of the Dhirpur wetlands in Delhi, where basically real estate development was being carried out on the wetlands itself, and the NGT restrained them from carrying out those activities. Then, so basically, I mean, I will not go into, there are a lot of judgments passed by the various high courts, whether it's Jammu and Kashmir, whether it's Delhi, whether it's Calcutta, Tamil Nadu, Kerala. All these courts have dealt with the issue of wetlands in their respective states. When we come to the Supreme Court basically, as I said, the Constitution does not have a provision for right to water, but in subsequent judgments from 1970 onwards, basically from 1991 onwards, the Supreme Court basically said that the right to water, and not only right to water, but right to clean and hygienic drinking water, is a fundamental right and forms a part of right to life under Article 21. It is in that context that from the 1990s onwards, the Supreme Court basically expanded the definition of right to life under Article 21 and said that there were 3-4 issues raised. One is that as far as right to water is concerned, it forms a fundamental and integral part of right to life. The second aspect was that where natural resources are concerned, like air, water, hills, hillocks, mountains, forests, etc., these are all natural resources which belong to the people, and therefore they need to be protected. And the state acts as a trustee in protecting those natural resources And therefore, as a trustee, these resources need to be protected. It is in that context that the doctrine of public trust, which was first enunciated in the United States, came to be adopted in India also. And the most famous case of the doctrine of public interest is the MC Mehta case, where basically a hotel was sought to be constructed on a river bank, and the court said you cannot, private parties cannot take over public natural resources. So we have a series of judgments on the doctrine of public trust, and I would also focus on the issue of the public beaches that are sought to be privatized, and that in that context, the Supreme Court case in the Fomento Resorts case, which basically said that beaches cannot be privatized, and that public have access to beaches. So I mean, there are a number of judgments on the doctrine of public trust, which I need not go into. But two most important cases.
Ma'am, sorry to interrupt you. You just mentioned the fact that there was a judgment passed that, private owners cannot come and have establishments on public property. So does that mean the government has the right to, it's a public space, right? So under the name of economic development, when we have the government taking away these wetlands and things like that, like there's this question from Mr. Nandakumar, who is saying that there are several orders, several judgments, notifications, which ask for the protection of these wetlands. So which is, he's specifically asking about Uran is the largest coastal wetland of Maharashtra. Huge landfills are underway here. Hence, how can these usually, biodiverse water bodies be protected?
Yeah, so basically, as I said, first of all, there is no strong law in India. So basically, we have to take resort to Article 21, and of course, there is the Wetland Rules. I am not totally disregarding that. Of course, we should take advantage of that. But the point is that really, I mean, it all depends on the predilections of the High Court judges or the judges in the Supreme Court. If they feel it is important, they will protect it. If they don't, they will not. So basically, it also depends on how strong the civil society is at the grassroots level to be able to oppose it. Because we are a part of the international community, we are signatory to the Ramsar Committee, we abide by the definition of wetlands under the Ramsar Committee. We also have incorporated it into the Wetlands Rules, and maybe in respect of the state rules, we should have a much more stronger state enactment, which will basically protect all these problems that we are facing right now as far as wetlands are concerned. But as far as the public doctrine of public trust is concerned, we should use it more and more in our cases, because one very important case which dealt with this issue was of a park which was sought to be dismantled by an underground parking space in Delhi, which was basically MI Builders versus the union. And the court said that you could not give public property, public resources or public natural resources which belong to the public to a private builder by constructing an underground road. So here in Uran, in Panje, the entire wetland is sought to be given to a private party, which is basically Reliance, and they are sought to, this destruction of the mangroves is being done at the behest of Reliance, who are basically trying to set up an SEZ. And then I come to our Supreme Court law and our High Court judgment on this, which seeks to protect the wetlands. So the most important Supreme Court judgment is the judgment of M.K. Balakrishnan, which basically said that though it started in 2006, I'll just take 2 minutes and I'll finish, is that in 2006, this petition was filed. At that point of time, the issue was the problem of drinking water, that there was shortage of drinking water, that ponds were being destroyed, etc., etc. And there's an order by Justice Kajju at that time, who said that you must protect the ponds because the country is anyway facing a problem of shortage of drinking water. However, that petition got expanded into the issue relating to wetlands. And in 2017, much after the, slightly after the new wetlands came into the field, the court said that you cannot, if you are not taking any positive steps in protecting the existing wetlands, that you must protect the existing wetlands which exist under the Wetland Atlas rules, which were about 2 lakh wetlands, which were basically more than 2.25. And there are another 5 lakh wetlands which are less than 2.225. The Maharashtra government is trying to make out a case to say that it's only those wetlands which are more than 2.25 hectares which need protection and not less than. There is no such definition of wetlands under the wetland rules, that only those which are more than 2.25 hectares should be protected. So this whole argument that only those which are more should be protected is false. And the Supreme Court basically said that at least those 2 lakh wetlands need to be protected, which have been identified under the wetland rules. This is the law today. The Supreme Court judgment is the law today, and they need to abide by it. Most of these wetlands which are being destroyed, like for example, the Uran, the Panje, the golf course in Navi, Mumbai, all these are wetlands which are covered under the Wetland Atlas, and they cannot be destroyed. The second part of our argument has been that Vanashakti had filed a petition in 2013, basically saying that though the law of the wetland rules came into being in 2010, till date, no brief document under the wetland rules had been prepared. I will not go into what a brief document is. I think everybody knows that. A brief document has to be prepared by the state government identifying the wetlands in the state. No such document has been prepared, and therefore we went to the High Court saying that this needs to be done on an urgent basis, because on a daily basis the wetlands are being destroyed. So on 14/10/2013, and that's a very important date because that order still stands today, the court said that no construction, no reclamation of land and no construction on wetlands should be allowed. This is the order today. So here you have a wetland which is being destroyed under our very eyes, and none of the officials, either under MCZMA or under the Environment Department, have even done anything to stop that reclamation. This is today the order as it stands. Subsequently, the court again said, because it was pointed out that large numbers of wetlands are being destroyed, a contempt petition was filed. And in the contempt petition, the court said, please give us details of how you have complied with our order. Till date, that has not been complied with. Then finally, the courts said that in cases where non-compliance is being done, FIR should be registered. Till today, not a single FIR has been registered. And even if it is registered, it is done in such a clumsy fashion that one is sure that most of these offenders will go scot-free if the investigation proceeds further. And finally,
so,
on 16/7/2016.
Hello, ma'am. You said the FIR needs to be registered. FIR needs to be registered by civil society organizations, the public, or who?
No.
Who is
so that is the problem, and that is why Justice Oak in the Navi Mumbai judgment dealt with the issue of criminal complaints and said that the complaint, even if it is filed by an officer who's not delegated under the Environment Protection Act, it will not become a nullity. All that will happen is that the official who is supposed to file it should come and replace that person who has filed it. So say, for example, a Tehsildar files an FIR against XYZ, and that Tehsildar has not been delegated under the Environment Protection rules, but some other forest officer has been delegated. Then the forest officer will come in place of the Tehsildar and proceed with the investigation. The problem is this, that the Tehsildar who files the FIR does it in such a clumsy fashion that at the inception itself, the FIR becomes a totally a complaint that cannot be proceeded with. So the major problems that we are facing is at that level, because civil society has no powers to file an FIR. It's only the officers who are delegated by the central government. So finally, when we come to the order of Justice O in the Vanashakti case, there's an order of 16/7/2016 which says that all the interim orders will continue. And as a result of the interim orders, the state government has issued a circular, and it's very important for activists to know this, that the state government has issued a circular to all the planning authorities, whether it is the BMC, whether it's the corporation or the councils or the panchayats or SITCO or any other authority, that they will not allow any reclamation and construction to be carried out on the wetlands. This is a very specific order. It stands today, and this order is not being complied with at all. So basically, what I feel is that you can have a lot of good orders, you can have a lot of good circulars, but if and in this case, civil society is active. I mean, they've been raising objections with regard to the golf course, they've raised objection with regard to Panje, and it is at their instance that some of the activity has stopped. And I think that that is the only way by which we can really proceed further, but we can do that only if we know what the law is and what are the weaknesses in the law and how we can overcome that. So now lastly, I would just conclude by saying that in the 16/7/2016 order, there's a grievance redressal committee that has been formed, in which Stalin is one of the members. And he can also in the discussion, I think, point out the frustration that he feels, since the committee has been basically not functioning. All the important officers do not attend the meetings, so no decision can be taken with regard to the complaints that are made to the grievance redressal committee. This is a committee that has been set up by the High Court, and that is supposed to look into the complaints and take action against the complaints. And lastly, I would just mention the Navi Mumbai case, because that is also a very important case.
Ma'am, I really
time is over.
Have a little more time.
Okay.
Yeah, but before we start taking questions from the panelists, which some of the participants are also asking for, is that civil society plays a very important role. So, Stalin, what are the kinds of problems that you have to face, or what civil society organizations face, and how can they come become more aggressively take charge of the situation and be more proactive to
as a member of the High Court appointed Wetlands Grievance Redressal Committee, it has been a long and frustrating battle for me. But I have done my I've worked out of my skin to save much of the wetlands which came as complaints to us, but that has come at a very high intensity of work. The thing is that the government officials, like ma'am said, that they don't bother. Most of the complaints that come to the committee, Wetland Grievance Committee, are concerned with coastal wetlands. So we have the High Court has appointed the Environment Department to attend these meetings. But you will be shocked to know that for the last 4 years, not a single representative from the Maharashtra Coastal Zone Management Authority has attended the meetings. And at every meeting, I keep insisting that this be brought on record and the notice be issued to the Secretary of Environment to attend to send someone for this meeting, but nothing happens. Nothing happens. You will tell you, it is only on the basis of the wetland atlas which we are trying to show that there are wetlands existing and these need to be protected. Even there, we are facing so much difficulty. There is a complete opposition from the government side. Let me tell you, the entire machinery comes together to defeat you. They don't want citizens to take up these issues. They don't want to. The first thing when a citizen goes on that site to see and complains about reclamation, who are you? Why have you come here? That is private property. They will do what they want. What is your authority on this? You are trying to stop development. Then they try and put cases on you. They intimidate you. They get the local mafia to come and bully you. All these things have been done. So citizens have literally been crushed. They can't really fight back and do much about it. But what they have done very nicely is that they have sent complaints to the Wetlands Committee, which have been documented. Since the court battles are going on, like ma'am said, it's a question of a sensitive judge who is concerned about the environment. The day that matters come up before him, all these officials will pay the price for it. And we will wait. It's a waiting battle. I've fought this for the last 7 years. I'll fight it for another 10 years. But we are not going to let them get away with it. And like you said, wise use of wetlands, which was mentioned, paddy fields. Paddy is cultivated in the coastal wetlands in monsoon because the salinity is low and the paddy that you get is very good quality. So it's a sort of resistant and high protein paddy which you are cultivating. But today, if you see, the wetland rules have been changed, the paddy fields have been exempted. So now paddy fields, instead of sprouting paddy, are sprouting buildings. Now, if you go across the state of Maharashtra, the last government has been merciless. In fact, they have inaugurated townships on these areas, and reclamation, like you said, it's happening on a daily basis.
What is the solution for this, Stalin? Like
I said, the Supreme Court has given certain orders, which are, and the High Court has also reaffirmed and said the same orders. Whatever is seen in the atlas has to be protected. And if we as humans don't value water, then we are doomed. What we can do today is to make sure that the complaint is, you have to pinpoint accountability. Every citizen has to maintain a clear record of whom he has complained to and take acknowledgement. If they're not giving you acknowledgement, send it by registered post. Okay, and make sure and keep it online or whatever, and keep all your complaints online. So eventually that officer will have to account for what he's doing. Now, what the government very cleverly does is that it keeps transferring the top official very frequently. So they say, no, this happened during my term. I didn't get time to do it. This will be the excuses which will come on later on. So it is a remember, you're one citizen against a well-networked group of people. They each one supports the other and tries to cover their back. Now CIDCO and JNPT, they are both run by bureaucrats who are heads of organizations with huge resources at their disposal. So no official of the revenue department or of the forest department has the guts to go and challenge it. You mean to say a forest officer is going to file an FIR against the MD of JNPT? He can never do it. A circle officer, he dare not write anything against those people. While the law says that the head of the organization should be named in the FIR. Not a single FIR. All FIRs are against unknown truck drivers. Now an unknown truck driver comes into my plot, fills up my wetland and goes back, and I don't know what's happening. It's a very convenient way of allowing them. So even the police, see, and the problem is in the law. If the only body which is really acting today is the forest department. Whatever they can do in mangrove areas, they have aggressively protected it, and I must give credit to them for that. But in the non-forest areas, they are helpless. Their reports hold no value. They are doing their best. They send their report saying that this land is being destroyed. Please do something. But it is never, no cognizance is taken about it. So citizens, like you asked, can only file complaints and keep a record of it and send it to the court. That's what they can do.
Thank you, Stalin. These are, I think, very, very important steers you have given to all the citizens and active students who are part of the panel. I'd also like to request, since we have run out of time, these questions which have come from Suhas Joshi from Lok Satta, if Farah, you can read them because they're in Marathi.
Yes. I will read it out. But just a quick question before that is one by Nikita Jacob, which is very simple. Has the PIL been kept open for monitoring implementation?
It is.
Yes?
Yes.
Okay.
It's ongoing. Yeah, it's not closed.
It's ongoing. We have a question from Suhas Joshi. He is talking about the Ramsar. So basically what we have 37 wetlands which are which are a part of the Ramsar Convention, right, which have been kind of noticed, which are to be conserved. These are really, really important wetlands. So when we say that, these are the 37 wetlands, when actually there are thousands and thousands of wetlands in India. Okay. So what do you think about it? How we get more numbers onto that? And what do you have to say about it? I mean, in general, does that mean that the rest of them are not?
The hypocrisy of the government is exposed. Let me explain this. When they changed the wetland rules, they in 2017 they brought in the new rules and they said the man-made wetlands are excluded. Okay. Now last year they declared one man-made wetland as a Ramsar site, Nandur Madhveshwar at Nasik. So where it suits you, man-made wetlands become important. Where it doesn't, it is not possible. So the hypocrisy is of the ultimate level. So why man-made wetlands were removed? Because salt pans fall under man-made wetlands. If salt pans are removed, Mumbai's construction mafia will come gunning for you. So they want to keep that open.
Okay.
So here is the hypocrisy. See, Ramsar, we have just signed the Ramsar Convention. I'll tell you my personal experience when Kanjurmarg dumping ground, 141 hectares was being reclaimed. That is a wetland which has been identified even by the American wetland inventory. The Americans have the record that it is a wetland. And when I wrote to Ramsar, what Ramsar did was send a note to a local officer in the MOEF who did not bother to write on it. And I kept writing to Ramsar and nothing happened. These people hold important conferences, conventions, have nice time, make grandiose statements. Action of Ramsar in India is zero. They have not bothered to do anything for conserving wetlands in Maharashtra or in India. So whatever we have to do, it has, like ma'am said, the local people need to own up to their own biodiversity. See, the government owns nothing. Let us realize this. Whatever is there is public property. Government is administering you under the public trust doctrine. Every natural asset has to be used with the permission of the public. Today, does the government ask you anything? No. They come and tell you, we are going to have this project here, you better adjust to this. No, it can't be that case. People need to own up to their local biodiversities, which has been done. In Sindhudurg, many places, the people have said, these are our wetlands, you should not touch it. The Myristica swamps, for example, the local village took control of the swamp and introduced a ticketing system for people who want to come in to see it. So they started generating money through that and protecting it. So it is when people start owning up to their own the natural biodiversity, then things will change. The judiciary, like it's always a gamble. We keep trying, we plead. And the first thing is to prove yourself that you don't have an ulterior motive. But that is the strangest part of it. When you go into court as an applicant, the first thing the opposition gangs up to show that you have a vested interest, where you don't have none, you have nothing to do with it. You are doing it in larger public interest. So it's a tough battle, but citizens need to keep plugging away.
Okay, one last question before we, finish with this session. And that is, Gayatri ma'am, like you were, when I interrupted you, you were talking about the, a very important case about the Navi Mumbai, which falls under the Mumbai metropolitan region. So besides that, I would also like you to give one example of, a green space which, we were successful in protecting, through the combined efforts of organizations, civil society organizations, as well as legal fraternity.
I would just talk about Navi Mumbai and maybe Zaman can talk about the success part because I can't think of success.
Okay.
So the first part about the Navi Mumbai is that it basically reaffirmed the Supreme Court judgment and the Vanashakti judgment. The second most important part was that as the wetlands are being removed from the wetland rules seeks to remove wetlands which are in coastal areas. The reason for this is because under CRZ there are certain zones like CRZ2 which allows development and allows certain permissible activities. So basically the argument of the golf course project proponent was that part of the golf course fell under CRZ2 and part of it fell in CRZ3, which is a no development zone, but now which is sought to be removed. That categorization was sought to be removed by the development planning authority. The court said no, it is the wetlands itself as a wetland that needs protection, whether it comes under CRZ or not. This was a very, very important finding because right now we are having major problems by the government trying to remove the wetlands and put it under CRZ and say that under CRZ you are allowed to carry out certain permissible activities. Now, of course, that issue has gone before the Supreme Court, the Navi Mumbai case, and is pending there. but the golf course authority, the project proponent has made an application to the authorities saying that it is no longer wetland and kindly remove it from the wetland atlas. That application, I don't know what has happened to it, but it seems to be pending right now.
Thank you, ma'am. Zaman, can you,
Yeah.
you understand, we all understand that, now the importance of young people, especially young lawyers, to come forward to be able to raise their voices. So whilst you are doing that, can you give us one example of, which you've had success with?
So at a personal level, we do have examples in Madh, where a pond has been continued to get protected after the local citizens have come out. In fact, another example, which though I was not involved, but we have seen that happen in the High Court, was another example from Navi, Mumbai again, of a wetland in Kharghar, where the residents had come together and come forward and which helped. Other than that, when you look at local communities, we have seen those examples coming out in the Northeast, especially the Loktak Lake and also two lakes of Bangalore, which had caught fire. We had a lot of people coming together and taking this issue before NGT. So people do take up, there are successes. It's not the case that we face mounting pressures, but it's a question of everyone coming together, especially all the young ones, and putting their voices out.
What do you think made it a success? Stalin, his hand is up. Yes,
Yeah,
Stalin.
my hand is up because if you ask for successes, it is the fact that the High Court has ordered that all the wetlands which are seen in the wetland atlas are protected. That is a starting point for all citizens. You have a High Court order, you have a document. Your fight starts there. At least you're lucky enough to see a wetland in the atlas. It means it has to be protected. They can't run away from it because that is an order which has been affirmed and by the Supreme Court also. So there are two orders of the state and the central at the highest level in the judiciary which have protected this. So that's a starting point for citizens. And I personally see that as a big success. To get that kind of orders, it takes a lot of work from the judge's side also. Not to mention, of course, the lawyers who are doing it tirelessly.
Yeah. Arpita, there's one last question from Burgess. His hand has been raised. Can you unmute him so that he can ask his question?
Sure.
Just a minute, Burgess. Yeah. Burgess, can you
try to? Yes.
Yeah.
Yes, go ahead.
No. Hello, Burgess.
He's on mute.
Yeah, I can't see his. So basically, he had.
Can you hear? He's on.
Yes, he's on. Yes, Burgess, we can hear you.
As a young citizen, I just have a question, basically, seeming that it's a very difficult challenge to oppose such vested interests in these matters. What can the average citizen really do or sensitize themselves so as to overcome such unfortunate situations?
Citizens are sensitized. It is the bureaucracy and the government officials who need sensitization. I don't believe in this awareness initiatives. You go to the local corporator, start with him and tell him, learn about wetlands, learn about the environment. You can lay tiles and bring water pipes alongside learning about the environment. You have to start educating the political class and the bureaucracy. I am not insulting anyone. I'm very serious that the environmental disconnect in the bureaucracy is heartbreaking. You need students, you need to approach them, make them part of your projects and ask them, what do you feel about this? Well, right. Let us not get carried away by these standard statements. Development and environment must go hand in hand. We are all for sustainable development. Remember, these are two sentences used by people who want to sanction destruction. You understand the environmental issues and then comment on it. You go after your own local politicians and start changing them at that level. Make environment a election issue. Make it a political issue. Only then can we get somewhere. For example, the RA battle became has reached such a level that it is all because of the people's fight and made it a political issue finally. The government had to leave. The earlier government had to fall. Yes, ma'am. Sorry, ma'am. Ma'am wanted to say something. I interrupted her.
One last question is that Stalin, one of the participants has raised a question which is asking that it's often farmers who are living around wetlands may not be supportive, towards the preservation or conservation of wetlands. Is that true? And
No.
how we go about sensitizing them?
No, it is wrong. The farmers are not affected. Cultivation of paddy is still allowed, and we have never opposed any farmer who's cultivating paddy. We are all for it. But remember, when you convert paddy fields into concrete spaces, like it was done for Kochi Airport and for Chennai Airport, you create floods, you create misery. So people generally, what they do is they buy off these farmers and then they construct. I'll tell you, there's a huge township on the banks of the Dasai River at Dombivli. Those were farmlands which were inundated by the floodwaters. The farmers were told to make an application to the MCZMA to build walls to protect their farmlands. They made that application, they got the permission. Today there are at least 200 buildings standing there. Okay, so let us not get carried away. Any farmer who is actually doing his farming will not be touched. He cannot be touched. But if he's going to sell it and builders are going to come and make buildings on it, we have a serious problem with that.
Okay, thank you so much.
Ma'am was saying something. Gayatri ma'am was saying something. I think
yeah.
No, it's okay.
I'm so sorry. Yeah, okay. Suhas Joshi from Lokmat, I don't know if he's here, but I hope I've answered all your questions. If you would like to ask more questions, please raise your hand now, because otherwise then we'd like to close. I think he's not there, Arpita, so we can close the session now. I would like you to, yeah.
Yes.
We hope we get more
for
lawyers for the environment coming from your groups.
Sir, we are definitely
Zaman needs a big army behind him, and I think Gayatri ma'am also needs a lot of forces with her. So please put together a nice army of lawyers for the cause, because this is for the tomorrow's generation. We are in a very critical stage. We are at a tipping point, and we've already started the slide downhill. So if you wake up now, it's better. And more lawyers. See, one thing I would like to, with your permission, tell that the lawyers don't think that becoming an environment lawyer means carrying a jhola or working free of cost and working out of a makeshift office. No, it's not so. You can become a consultant for big projects where you can advise them on environmental issues which will delay their projects. So you can make money and do your conservation also at the same time. So don't ignore environmental law. Today, the country needs serious environmental lawyers. There are very, very handful of lawyers. Zaman and Gayatri ma'am are one of very few lawyers who really understand and fight for the environment. So we need more of their kind in this battle. That's my request to everyone.
Thank you, Stalin, for your very, very good thoughts around this. I think we have a bunch of young lawyers, and I'm hoping we can circulate this recording to more and more students and law students, especially across the city. These are important points. So don't work for free. You can make money while you work for the environment. That's the key message I'm taking from this. And I think my life is an example, and Farah's life is also an example of this. Very, very helpful example from Gayatri ma'am and Zaman, your inspiration for all of the young lawyers. I really appreciate you coming on board for Biodiversity by the Bay campaign. The revision of Wetland Rules is an important example of what's happening in the city and the country overall. And the idea about Ramsar Convention, the declaration of Nandpur, it's difficult to pronounce, but I think
Nandan
Madhveshwar wetlands that happened in the last few years is a very good example. I was not aware of it, and we perhaps have a lot of important wetland and biodiversity spaces within our city and in the coastal region of the state. And I think what we can do is send this recording across, and all of the questions which were not addressed, I hope some of them we have been able to address, but all of the questions which have not been addressed, we'll be circulating and sending all of our esteemed panelists as well. Thank you for your time. Thank you for working on a Saturday. I know you all already do. And thank you for working to protect the city's green spaces, Stalin. You are an inspiration for all of us, and Gayatri man. And Zaman, all of the support, and if we can get you some interns, we can get you some support from this campaign, I would consider this a success for us. We will be closing it now, but all of the questions that we couldn't take, we'll be addressing in the future conversations as well. Thank you, Farah.
You can send it on email also.
Yes, absolutely, we'll do that.
We'll share it with you all, and all the attendees. All your questions will be answered, and we'll send you an email. Thank you so much.
Thank you, Farah. Thank you.
Thank you.
Thank you, Bhagwan, for putting this together. We are looking forward to more of these conversations in the future. Thank you all. Have a great weekend ahead. Bye.
Thank you.
You too.
Thank you.